Today's webinar is presented in partnership with the National Health Law Program. Today's presenter is Youdelman, Managing Attorney at the National Health Law Program. This webinar will provide information on marketplace appeals, detailing which decisions can be appealed and how to file an appeal, as well as ways to expedite the appeal process. And with that, I will turn it over to Mara.
Great. Good afternoon, everyone. And I'd like to thank everyone at the Center on Budget and Policy Priorities for inviting me to come speak on this webinar today. For those of you who aren't familiar with the National Health Law Program, or NHLP, we just celebrated our 50th anniversary, focusing on healthcare access and quality for low-income and underserved individuals. We're going to go through a bunch of issues related to marketplace appeals. The brief agenda is on this slide, so we'll talk about when an eligibility decision can be appealed, the role of assisters in appeal, how to file appeals, and how appeals decisions are carried out or implemented. So let's start with marketplace eligibility appeals. And I am mostly going to be talking about appeals for the federally facilitated marketplace. When it's possible, I'll point out some of the differences between what happens for appeals related to healthcare.gov and those related to your state-based marketplaces. But I do just want to clarify, if you're in a state with a state-based marketplace, there likely are going to be some differences, and you'll have to do some investigation as to how appeals work in your state as you go forward. The broad overview is that any consumer who feels that an eligibility decision has an error in it can file an appeal. The way this happens at the federal marketplace is appeals go to the Federal Appeals Entity, or the FAE. This is actually part of the Department of Health and Human Services. It's the same entity that handles Medicare appeals and may also handle some Medicaid and CHIP appeals. The first section that we're going to go through, we'll walk through what determinations can be appealed. And this is really important because there are a number of situations when an appeal may not be ripe. And if a consumer files it, it's just going to be dismissed. And that doesn't help the consumer in any way, and it also doesn't help the appeals entity be able to decide appeals in a timely manner. So the most important thing to realize as to when something can be appealed, it must be final decision. Any interim or temporary eligibility or temporary decisions cannot be appealed. Consumers in those situations have to wait until a decision or a determination is finalized, and then they will be able to appeal. Second, an appeal must be of the appropriate subject matter. That means only certain issues are eligible for appeal. And we'll spend some time during the webinar walking through what can be appealed to the Federal Appeals Entity, and instead what also might be appealable either directly to a state agency like the Department of Insurance or directly with an insurer. So let's start walking through this. Before consumers file appeal, usually the best first step is going to be to see if a consumer can actually get an eligibility determination that they feel is correct for them. So if a consumer fills out the healthcare.gov application, or a request for a special enrollment period, or is replying to a request for more information, if the consumer gets back a decision from the marketplace that they think is wrong, the first thing the consumer likely is going to want to do is actually call the call center or try to get some other assistance as sort of a first line of defense and see if maybe a mistake was made that could be corrected before having to go through a formal appeals process. Many of you may know that if the call center cannot provide direct assistance, consumers can actually request to have their case looked at by a team of caseworkers. And there are a couple of times when casework might be appropriate before filing an appeal. So in this case, in these types of cases include complex eligibility or coverage issues, certain special enrollment periods, or questions with regard to a 1095A that comes in at the end of the year that documents the number of months that a consumer has coverage from. In these cases, again, calling the marketplace call center is likely going to be easier and get a more timely resolution than actually having to file an appeal and go through that entire process. There also are certain issues which the Federal Appeals Entity is not going to be able to address, and these need to be brought to the attention of either insurer or the State Department of Insurance. So let's first start by walking through appeals that need to go to an insurer. And again, there's some types of issues that can be resolved here. So for example, if a consumer has concerns about out-of-network providers, maybe a provider was listed as in-network and then a consumer goes to the hospital and ends up getting bills, as we've all seen, surprise billing, where the consumer says, well, I went to an in-network hospital, but then didn't realize they were actually seeing out-of-network providers within that hospital. So that would be an issue that could be appealed to an insurer. Same thing if an insurer says, denies a request for services. This might be denial of physical therapy request, denial of prescription drug coverage, denial of home care, things like that. Or if an insurer canceled coverage. In any of these situations, if it's directly related to a specific healthcare service or a decision about benefits or services that are made by the insurer, these are not going to be able to be addressed through the federal appeals entity. In this case, the first step that a consumer should take is file an internal appeal with the insurer. And then if the internal appeal is not resolved satisfactorily for the consumer often has a second option of an external appeal. This can be to an independent third party or possibly to the state as well. So again, just to sum up this slide, if a consumer is having issues with the receipt of a particular service or the denial of a service, those denials have to go to the insurer and not to the federal appeals entity. The next opportunity for consumers to look for help with decisions that are made not in the consumer's favor focuses on the Department of Insurance. And again, there's certain types of claims which might be resolved better by the Department of Insurance. Again, this could be the external entity a consumer would go to after an insurer denies a service. A consumer files an appeal with their insurer. The insurer continues to deny it. Then the consumer can go outside of their insurance company and go to the Department of Insurance. The Department of Insurance is also likely the best bet for consumers who feel that they were terminated from coverage incorrectly, issues about providers allegedly being covered by provider directories, but then getting billed for out-of-network services, denials for claim, or the fraudulent sale of health insurance. Again, in these situations, the best bet for the consumer is going to go directly to the Department of Insurance. If they do file an appeal with the federal appeals entity, it's likely going to be denied as not within the subject matter that the appeals entity can address. Okay, so now that we've talked about what the federal appeals entity can't do, let's talk about what the federal appeals entity can do. And here on this slide are a list of the types of decisions that can be appealed. These can be appealed if you're going through healthcare.gov to the federal appeals entity. If you're in a state-based marketplace, these would be appealed through the system set up by that state marketplace. So the types of decisions that are ripe for appeals within the marketplaces themselves is denials of APTCs or CSRs. A difference in the amount of APTCs. If a consumer thinks he should be getting more APTCs than was granted on eligibility determination. If a consumer loses APTCs at the end of an inconsistency period because there's still a question about the consumer's income and what was provided in application versus what may have been accessed from federal data sources. Other issues like denial of eligibility, denial of a special enrollment period, if the marketplace terminates the insurance coverage rather than the insurer terminating insurance coverage, and some of these other things. So in this case, this is when applying directly to either the marketplace, federal appeals entity, or to a state-based marketplace is going to make sense. There are also certain times if a consumer does apply within their state-based marketplace that they will have a second round of appeal available through the federal marketplace. So for example, let's take a consumer who might be in California, which has a state-based marketplace. If a consumer receives a final decision on her appeal from Covered California, for example, and the consumer still disagrees with that, then the consumer can appeal to the federal appeals entity and seek a second opinion on that. This is going to work for marketplace issues. If the consumer was denied Medicaid or CHIP eligibility, that's not going to be able to be appealable up to the federal appeals entity. And at the bottom of this slide is just a list of the states that use state-based marketplaces. So again, if you're in one of these states, it's really important to look at what the policies and procedures are in your marketplace for filing appeals, as they may be different from what I'm walking through at the federal marketplace. So as I mentioned briefly before, as we start to get into a little bit more detail about when consumers can file appeal, the most important thing to remember is an eligibility determination must be final. Decisions are not final if they're listed as temporary eligibility or if there's a data matching issue. So if a consumer receives an eligibility notice that says, we think you're eligible, but you need to provide us more information about your citizenship or immigration status, for example, that's considered a temporary decision. And the consumer either has to wait until they've resolved that inconsistency or wait until the time period for resolving the inconsistency is over, and then they get a final eligibility determination from the marketplace. So again, it's really important from a timing perspective and to make sure consumers are going in the right time when they actually can get relief, that you're waiting for a final eligibility determination. So let's walk through an example here of what can be appealed. And if we take the case, and again, these are just all hypothetical cases, but the case of Susan, she's determined eligible for marketplace coverage with APTCs, and her daughter is assessed eligible for Medicaid, and her application is going to be sent to the state Medicaid agency to make a final determination. What can Susan appeal? Well, the first thing, because she was given marketplace tax credits, is she was effectively denied Medicaid eligibility. So if she thinks she's eligible for Medicaid, she could appeal and see if she's actually eligible for Medicaid. She could also appeal the amount of tax credits she's eligible for. So if she thinks she received too much or even too little tax credits, she can appeal that decision. What she can't do in this situation is appeal Ilana's assessment for Medicaid. So in this case, if Ilana's application has been sent to the state Medicaid agency, she's going to have to wait for a final determination on whether Ilana is eligible for Medicaid, or if Ilana comes back to the marketplace and receives marketplace coverage. If Ilana receives Medicaid, she's not going to be able to appeal that determination through the marketplace. She'd have to go to the state Medicaid agency. If we take another example, and this one plays out the issue of temporary eligibility, we'll look at the situation of John. So he receives an eligibility notice that says he's eligible for APTCs. But it also says that this decision is temporary and he has to provide proof of his citizenship status. Even if he thinks that this is a wrong determination because he was born in the United States and has been a citizen all his life, he actually cannot appeal that until he actually either resolves the citizenship inconsistency by providing documentation to the marketplace, or at the end of the determination, when the marketplace sends a final eligibility notice, he can then contest it at that point. So it's really important, again, to remember that sort of two pieces of this. Of one, you first need a final eligibility determination, and two, it has to be of a type of decision that the marketplace can focus on. So again, the marketplace generally can't reassess Medicaid and CHIP eligibility. That's going to happen through a state agency. Okay, so we're going to shift now from sort of what are the causes of action or what are the reasons someone can file an appeal, and go more detail into how to actually request an appeal. And we've got some new developments this year that are really exciting because we've been waiting for them for a long time. So for the first time, there actually is an online appeal form that someone can fill out and submit directly online and get the appeals process started. So this is really exciting because up until this year, individuals have had to either fill out a PDF form, print it and mail it in, or write a letter and mail or fax it in. So we really hope that this is going to streamline the process and also avoid issues about did something get lost in the mail or was a fax not received. So we really do strongly encourage individuals, if they are going to appeal, to use this online appeal form. That said, if there are reasons that a consumer chooses not to do that, they still have the other avenues for filing an appeal as well. So again, they can click on this appeal request form, fill it out, print it and mail it, or they can just write a letter. They don't have to use the official form. They can just write a letter explaining what happened and either mail it or fax it into the federal appeals entity. There is a time frame by which appeals must be filed, and generally that is 90 days. So if a consumer gets an eligibility decision, let's say on December 1st, they're going to have 90 days from December 1st to file that and appeal. If they don't file within 90 days but had a really good reason as to why not, maybe they ended up in the hospital or something else happened, they can request what we would say a good cause exception. But again, we really would strongly encourage folks, if they think that an eligibility determination has an error in it, to get it started within these 90 days for a number of reasons, but most importantly, because it can take some time to have all of this resolved, and individuals may have to pay the full cost of their premium while they're waiting for their appeal to be resolved. So again, 90 days is sort of the first important deadline to remember. If a consumer has their appeal dismissed, then they can actually request to have it reopened within 30 days. So that's the second bullet on this slide. And again, this gives sort of the consumer another opportunity to say, well, you know, you say you dismissed it because I didn't file this paperwork, but actually here's the paperwork. And then maybe I already filed it, or maybe I just happened to get it. A lot of times we see there might be delays in getting paperwork that's needed by the federal appeals entity. This can happen in particular around consumers who are waiting for confirmation from the IRS that someone filed their taxes. And sometimes it takes the IRS 12 to 16 weeks to be able to provide documentation after someone actually files their taxes. And the appeals unit's going to work on a quicker time frame. So in this case, if an appeal is closed because a consumer wasn't able to verify that they filed their taxes, they could request to have it reopened once they get that information from the IRS. The situation that I talked about in the second part of this slide focuses on when a consumer gets a final decision from their state-based marketplace, feels that decision is wrong, and wants to appeal it to the federal marketplace. In this situation, the timeline is similar to that dismissal of an appeal. So it has to be within 30 days of either the state-based marketplace making the appeals decision, or 30 days of the state-based marketplace similarly saying we're not going to reopen your appeal after it was dismissed. So again, in general, just to sum up, consumers usually have 90 days from a final decision to file a request for an appeal. There is a good cause exception, but we'd again strongly encourage folks not to necessarily rely on it. And in general, once a consumer gets a notice saying that an appeal has been dismissed, they'll have 30 days to file to have that appeal reopened. So there's another piece of this puzzle which has been slightly changed this year, which is really important to point out. For folks who are used to the Medicaid and CHIP context, you may think of this as aid paid pending. In the marketplace context, we call it basically continuing your tax credits during an appeal. Again, for some consumers, an appeal could take a number of months, and if they don't want to go without insurance, or they don't want to pay, for example, 100% of their premiums if there's an income discrepancy, they can request to have their eligibility continued and their tax credits continued while their appeal is pending. It's really important, if consumers want to do this, that they request this continuation when filing an appeal. While again, they have the opportunity to request it at a later date, it's the date of request that will allow the continuation, and you're not going to be able to go backwards. So let's say someone files an appeal, for example, on February 1st. If they file on February 1st and they say, I need my tax credits to continue, that can start on February 1st. If they don't request this aid paid pending on February 1st, but request it, let's say, April 1st, the continuation of the eligibility would go from April forward, but not go back to February. And if the individual was terminated from coverage, they're not going to be able to go retroactive either. So it's really important to think about whether a consumer needs to have their tax credits continue during an appeal and make that request up front. There are a couple of types of appeals for which this is most relevant. The first one is failure to reconcile. This is when a consumer may have filed their federal income tax, but it hasn't gotten into the system yet. So the healthcare.gov is going to say the consumer actually didn't reconcile their tax credits and not give them eligibility for the next year. The second is losing advanced premium tax credits, and the third is periodic data matching issues. And again, these all have to be final decisions. If there's a non-final determination, like an inconsistency, a consumer is not going to be eligible to get their tax credits continued during that time. So again, this is a little bit confusing. For consumers specifically in the failure to reconcile category, there will be a check mark on the form, the appeals form, where a consumer can specifically say, I want my tax credits to continue during this period. For these other types of appeals, it's not going to be as clear cut because only some consumers are eligible. So it's important to write it in or to make that request by calling the Marketplace Appeal Center. So now that we filed an appeal, let's go to the next step of what happens when an eligibility appeal is actually received. The first thing that the federal appeals entity, or FAE, is going to do is see if the appeal is valid. And again, this goes back to, is there a final determination? If it's not a final determination, the appeal is going to be found invalid and likely dismissed. If the appeal isn't filed within 90 days, it's going to be found invalid and dismissed, unless the consumer raises a good cause exception. So there's, again, a number of reasons why an appeal is not going to be, valid, and it's important to try to avoid those up front so that consumers don't get frustrated by saying, I filed an appeal, now it's dismissed, what am I supposed to do? So knowing when appeals are valid, knowing what grounds appeals can be filed on can really help ease this whole process for consumers so that they don't get their hopes up if they're not eligible for an appeal, and then they think they've just been stymied by another process. The next section that I want to talk about, and again, I am a lawyer, I'm not giving legal advice, but I work for an organization with a lot of lawyers. There's a lot of terminology that's involved in the marketplace and appeals that can be really confusing. And we do want to try to clarify when someone might actually want legal assistance as opposed to just someone to help them through the process, or like a navigator or an assister. And one of the causes for confusion is the use of the term authorized representative. And we use that, and we've heard that used in 3 different situations. So for example, when someone's filling out an application up front on healthcare.gov or on a state-based marketplace, someone called an authorized representative can actually represent the consumer with the marketplace. So they could talk to the call center even if the consumer might not be on the phone. And that usually will happen when you have a parent who is enrolling their child or the guardian of an incapacitated adult. In the appeals context, the same term, authorized representative, is used to refer to someone who's a legal representative. So this should not be someone who is an assister or a family member or a friend or someone else who works for a nonprofit organization. All those people can serve as witnesses for an appeal, can help provide support for an individual filing an appeal, but because an appeal is involving the legal rights of the consumer and their right to either continue coverage or get a certain amount of APTCs or other legal issues at play, we really do strongly encourage assisters and other advocates not to serve as authorized representatives for the appeals process unless they really are a lawyer and trained on how to do this. So again, you can be an authorized representative to help someone complete an application, but once you move into the appeals process, it is really important to think about what the consumer needs and whether they might be better served by reaching out to obtain legal assistance. And just to add a little bit more detail, there is definitely a role for assisters in the appeals process. In most appeals, the applicant or the consumer represents herself without assistance. And a navigator or assister can help explain the process to consumers, can help point consumers to the forms they need to file, can help access resources like an eligibility determination notice, an appeals form, can identify the deadlines for appealing, and refer the consumer on where to find low-cost legal help. An assister could also serve as a witness for a consumer in an appeal. So if the consumer is saying, I filed my application on this date, and there's a discrepancy in the marketplace, an assister might want to support that consumer and say, well, I actually helped the consumer on this date, and that's why I know that the application was submitted. So there certainly is a role for assisters, but again, because the legal rights of a consumer are at stake in an appeal, we really do strongly urge assisters to not take on the role of authorized representative, instead to provide a supporting role and possibly help the consumer find legal assistance. So as I sort of emphasized, assisters should not be providing legal advice. So for example, an assister could explain what the difference is between an appeal and an expedited appeal, but the assister should not be giving advice to the consumer as to which path to take. And so also just one thing I do want to clarify, even though I'm saying a lot of the reasons why assisters should not serve as authorized representatives, even navigators who are funded by healthcare.gov, they are allowed to be consumers authorized representatives. They can't do that with healthcare.gov funding. And they really should do it only if they are a lawyer. So there are some entities who might be getting funding as federally funded navigators who also provide legal assistance. And in that case, there might be a role for them to be an authorized representative. But it does need to be clarified that that's not being done with funding from the marketplace and also being done in a separate role. So let's take an example to walk this through a little bit more. We'll take the case of Ashley, who has an unresolved application issue. She tried to go through casework. It wasn't resolved in the way that she thought it was. And David is going to help Ashley file her appeal and followed up with the entity to make sure the request was received. The first step in the appeals process is having an informal hearing, which is a telephone interview with someone from the federal appeals entity and the consumer. So can David participate in the hearing on Ashley's behalf? Again, as I've mentioned, he can serve as a witness, that's fine. But if he's not a lawyer, he should not act as her authorized representative. So let me stop here and see if there are any questions that we should take at this point before we go on to some of the other examples that we'll go.
Thanks, Mara. So we do have a couple questions. First one is, if a consumer loses their appeal, do they have to pay back the tax credits they received during the continuation?
That is a possibility. And so if a consumer requests this aid paid pending and at the end of the appeal is found ineligible back to whenever the date of the appeal was, it is possible that the marketplace could ask the consumer to repay that. We haven't seen that happen yet, but it certainly is a possibility, and we would certainly suggest that consumers be informed of that. And so it likely is going to be a very individualized decision, whether it makes sense, based on the likelihood of succeeding in the appeal, but also potentially the expenses a consumer may face by not being enrolled in coverage. And as we're going to go through, I think a little bit later, there's also an issue that if a consumer decides not to have that continuation of appeal, whether they could actually get retroactive coverage and what the options are for that, but we'll discuss that shortly.
And beyond potential having to repay tax credits, are there any other reasons not to check the box for continuation of tax credits?
So this is if someone is eligible to have the continuation of tax credits during the appeal. I don't think that there are any other situations except the possibility of repayment that would lead one not to do this. Of course, if someone decides and is able to financially pay 100% of the premiums during the pendency of an appeal, they could go that route. And then at the end of the year, when they file their federal income tax forms and reconcile their advanced tax credits with the tax credits they should have had, they would be able to potentially get a refund for the months when they overpaid. There's also a possibility that if a consumer pays 100% of the premiums during the appeal is resolved in the consumer's favor, that they can actually make an arrangement with their insurer to give them a discount for the remaining months of the year since they've overpaid in the earlier months of the year. So I don't see any downside to requesting the quote-unquote aid paid pending unless it would be a serious financial hardship if the consumer is asked to repay.
Great, thank you. And as a reminder, if you'd like to ask a question, click on the Q&A icon in the control panel at the bottom of your webinar screen and type your question into the box. Turn back to you.
All right, so now let's sort of go through the appeals process in a little bit more detail and implementing eligibility decisions from appeals. So the first stage of an appeal is called informal resolution. This is usually done over one phone call or possibly a series of phone calls with the federal appeals entity. And I should clarify that there's actually two parts of the federal appeals entity. There's a contractor who accepts the appeals request forms and conducts the initial phone hearings with consumers, the informal resolution. If the consumer is unsatisfied with the informal resolution and moves on to formal resolution, that formal hearing is conducted by staff members of the Marketplace Appeals Group, which is part of the Department of Health and Human Services. So there are sort of two tracks that go through. What we've heard is for a lot of consumers, they actually can get a lot of their issues addressed through this informal process. So what happens on this informal hearing is the contractor will review the facts and the evidence. They'll have a phone conversation. The consumer can submit written documentation. Obviously, the appeals staff is going to have access to the consumer's application. And at the end of the telephone conversation, the hearing officer will, come up with a resolution. If the consumer is satisfied with the resolution, everything will be done. The appeals will be documented in writing, and we'll move on to implementation. If the consumer is not happy with this informal resolution, then the consumer can request a formal hearing, which will take place again with the staff of HHS and their appeal officers. So the second stage, it also is a telephone hearing. The consumer would get written notice at least 15 days prior to the hearing date, and it's presided over by a federal hearing officer. At this point, it's what's called a de novo review. It's completely new. So the hearing officer is not going to be bound by what happened in the informal telephone hearing. They're going to look at all the evidence. They're going to listen to any witnesses that the consumer brings. They'll listen to what the consumer says, and then they will make a decision about where the appeals happens. Consumers can present witnesses and evidence, and they have the right to review the appeals record before and during the hearing. They do have to make that request in writing, and everything, all the testimony is under oath. So it is important, again, this is why knowing whether someone's serving as a witness or an authorized representative is important. Consumers do have an opportunity to request expedited appeals. These are only available in certain circumstances when the standard time frame could jeopardize the appellant's life, health, or ability to attain, maintain, or regain maximum function. Normally, an appeals should be determined within 90 days. I'll admit I don't know what the current timelines are. Sometimes for more complex cases, it might take longer than that. And if a consumer is satisfied with the informal hearing outcome, that's usually a shorter process. The consumer is going on to request a formal hearing that may take a longer period of time because of the limited number of staff who can conduct the formal hearings. So if a consumer needs an expedited appeal, that needs to be noted on the appeal request. If the consumer doesn't do it right when they submit the appeal, but something comes up while the appeal is pending that gives rise to the need for an expedited appeal, they can call the appeal center or submit another request asking to expedite at that time. So let's go through a couple of examples here. If we look at Diane, who had her tax credits terminated due to an income data matching issue that wasn't resolved. She wants to file an appeal, but she'd have to pay 100% of the premium to maintain her coverage. This would be a financial hardship for her. Can she request an appeal? No. Financial hardship alone is not sufficient grounds to request an expedited appeal. Could she, in this case, request the aid paid pending? Yes, as long as she got a final determination on the income inconsistency, even if that income inconsistency is unresolved, she can appeal the final decision and ask for that aid paid pending during the appeal. So while she can't get an expedited decision, she could request the eligibility to continue while the appeal is going forward. In the second situation, the same person, but she has a chronic condition and needs monthly medication to maintain her current health status. In this case, could she request an expedited appeal? The answer is yes, because if she doesn't get her medication, her health may be at risk, so it's completely appropriate to request an expedited appeal. Again, it's important to note this because you want to make sure if consumers say they have a financial hardship that you explain to them that unfortunately that's not going to get them an expedited time frame, that it really is only if the individual's life or health or other situation is at risk are they going to be able to request the expedited time frame. After a hearing, and this is whether it's an informal hearing or a formal hearing, The hearing officer is going to make a decision based on the testimony, on evidence, on any witnesses, and any materials that have been submitted. The decision is in writing and has to be issued within 90 days of the date the appeals request is received, as I said, or administratively feasible. And again, it just depends on the situation and the timeliness, and sometimes even the time of year, how many appeals there are, how quickly individuals can get through this process. So the decision is final and binding, but may be subject to judicial review. So again, if a consumer has an informal hearing, doesn't like the result, asks for a formal hearing, doesn't like the result of the formal hearing, the individual could seek to go to court to get a different decision. I'll be honest, we haven't really heard of any of these cases going into the court system at this point, so there's no track record to say how successful people would be. After a consumer receives a final eligibility decision from the appeals entity, it needs to be implemented. So let's say that the consumer succeeds. They usually have two options. They can request that the decisions implemented on a prospective basis, so basically only going forward from the date of the appeals decision, or they can request retroactive implementation. And in that case, that would be where they go back to the date that the consumer should have received effective coverage or would have received if the initial determination was correct. If the consumer seeks this retroactive coverage, they're going to have to pay his share of premiums for the entire retroactive period and can't sort of choose a midway retroactive date. And we'll go through a couple examples to explain this. So the first example of retroactive coverage. If May was denied tax credits for coverage that would have started on January 1st, and she appealed and won her appeal in June, sorry, I used old dates here, but we're in 2017 instead of 2020. But if she ultimately was found eligible for tax credits in June, she had 6 months where she may not have had coverage. She can choose to either have her APTCs applied retroactive back to January 1st, or she can go prospectively starting in June. So if we walk this through a little bit more, if she didn't enroll in coverage in January because she didn't get an eligibility determination that was favorable and she couldn't afford to pay the 100% premiums, she can get this retroactive coverage, but she can only request it going back to January. So let's say she had something happen to her in April and she had a new condition diagnosed and needed care in April. She can't, unfortunately, request that the retroactive coverage start in April and go till May. Her only options are all the way back to her initial determination in January, or to start going forward in June and having that be prospective. We'll take another example here of the family glitch. So if we say that Benita's husband has affordable insurance through his work, but the cost to insure his wife is too expensive and she falls in the family glitch. So she applies to the marketplace and she's denied tax credits. Can she appeal the denial? Technically, yes, because she's dissatisfied with the eligibility determination. However, the appeal is going to be unsuccessful because the determination is based on the family glitch. And because she's in the family glitch, she's ineligible for tax credits. So unfortunately, while she could appeal and go through this process, the end result is going to be the same, that she's not going to be eligible for tax credits. So this is another example of a situation where while she technically may have an ability to file an appeal, it would be important to explain this to this consumer why that appeal is unlikely to ultimately be successful and save the consumer the time and energy that it would take to proceed with an appeal. So if we go through help with appeals, there are a number of different ways that consumers can request assistance. The first is calling the marketplace call center, and individuals can certainly call there and get some basic information on how to request an appeal. The second option is to call the Marketplace Appeals Center. This is the separate contractor who accepts the appeals forms, who will answer questions about whether forms have been received, and who will conduct that first line of informal hearings for consumers. So the Marketplace Appeals Center can answer questions about a specific appeal. They're not going to be able to provide general information about whether someone should file an appeal, but once an appeal is filed, they can start answering questions about that appeal and the timeframes for when an informal hearing may happen and other questions about whether materials are received. And then, as we mentioned before, finding an authorized representative to represent a consumer and provide legal assistance during an appeals process could likely be useful for a number of consumers because their legal rights are at issue here. And low-income consumers might be eligible for free legal assistance, and we've included a link here for the Legal Services Corporation, which can provide state-by-state resources of legal aid. There also might be a sister organizations who can provide referrals to legal assistance or other options available in consumers' individual states. So a couple of key points to remember. The first is how to file an appeal. Consumers can submit a form online, that's new this year. They can complete an appeal request form and mail it or fax it in. And they also do not have to use the formal or official appeal form, but they can write a letter explaining why they believe that a decision was made in error and submit that letter and request an appeal. The Marketplace Appeals Center first will try to resolve eligibility appeals informally, and that's done through phone hearing. If the consumer remains dissatisfied with the informal resolution, they can request a formal resolution. That's also done over the phone. The difference there is instead of the appeals contractor, the formal hearings are conducted by staff of the Department of Health and Human Services. And then ultimately decisions are mailed within 90 days of the appeals request being made, or as administratively feasible. And so we certainly know in past years a number of appeals have taken much longer than 90 days. And so again, that's a consideration for consumers to think about, both in whether they start the appeals process before maybe trying casework, and also whether they want to request the aid paid pending or the continuation of the tax credits while an appeal is being filed. So we have a couple of additional resources here. Some of them are on healthcare.gov, also a fact sheet, which includes some of those charts that we went through really early about when it's relevant to appeal to the Department of Insurance or an insurer or the marketplace. You can go through all of that. And we've also included a link to appeals forms. So I'm going to transfer it back, see if we have questions, but also announce the next webinar.
Thanks, Mara. We do have a couple questions that came in. Can an authorized representative apply for a person using the online form?
That's actually a good question that I do not know the answer to, but I will find out because the online form is new this year. They should be able to. There might, you know what, I don't know the answer, so I don't want to answer that, but I can find that out and get back to someone.
Great. Are there timelines for the informal hearing?
There generally aren't. So again, it depends on the caseload of the number of appeals that the appeal center is addressing. Sometimes it can happen relatively quickly. Sometimes it might be more than one phone call based on whether a consumer needs to submit additional documentation or wants to have a witness on the phone. So generally there isn't a specific time frame. I'd say if a consumer does not get any information or hear from the Marketplace Appeals Center within a couple of weeks of filing an appeal, they should certainly call and try to get an update. And so again, once an appeal is filed, they can call the Marketplace Appeals Center, ask about whether their appeal has been received, whether documentation to support the appeal has been received, and when that phone hearing could be. And again, they can also make requests for expedited appeals on the phone if something has changed since when they filed their appeals form.
Great. And for the expedited appeal, does that apply to the informal resolution process?
Yes, so the expedited appeal applies to the entire process. So if a consumer files an appeal and says it needs to be done in an expedited manner, that should apply to both the informal and the formal hearing. So it should be on a faster track overall. And again, it might depend on the caseload and when the request for the expedited appeal is made. But overall, again, if a consumer has requested an expedited appeal and feels that it isn't moving in an expedited manner, they should call the appeal center. The first question they might want to ask was whether the appeal center agreed that the consumer met the grounds for having an expedited appeal. And then if it's still not moving in a timely manner, they should request again that it be happening and try to get some more information as to how quickly things can proceed.
And one more question. In a situation where a consumer has both Marketplace and Medicaid coverage overlapping, and they are charged marketplace premiums, is that a situation that is eligible to be appealed?
So normally consumers should not have both marketplace and Medicaid coverage. There might be very limited circumstances if an individual might be on a limited scope Medicaid coverage, like for example, is only getting family planning services and supplies through Medicaid and therefore has full marketplace coverage. But generally, once a consumer is found eligible for Medicaid, they're going to be ineligible for tax credits on the marketplace. And given that Medicaid eligibility is usually for low-income consumers, it would probably be also pretty rare that a low-income Medicaid enrollee would be able to pay 100% marketplace premiums. So that is a little bit of an outlier situation. There also is a process called periodic data matching that the marketplace undertakes a couple of times per year. And what happens during the periodic data matching is the marketplace actually goes and checks the Medicaid rolls of all of the states. And if it does find consumers who have this dual enrollment, they're going to send a letter to the consumers and alert them of the situation and suggest that they cancel their marketplace marketplace coverage. Because in those situations, if they're Medicaid eligible and somehow there's an error and they're getting tax credits, they're going to have to pay those back at the end of the year. So it does sometimes happen, I will be honest, or sometimes it more often may happen that someone should be eligible for the marketplace and doesn't get a Medicaid denial. But again, if the consumer gets one of these periodic data matching letters that says they're enrolled in both, they might want to look into whether they need to appeal that if they think they, are being told they're eligible for Medicaid, but they're really not getting Medicaid. That might be a situation they would need to address.
And just to clarify, I think they were asking if the person had tried to cancel their marketplace coverage, but it didn't end up being canceled, and they had overlapping coverage for a month. Can that 1 month of premium be appealed?
Oh, I'm sorry. Yes. So let's say the consumer was waiting on Medicaid eligibility determination and had marketplace coverage. When they are finally determined eligible for Medicaid and enroll in Medicaid, yes, they should cancel their marketplace coverage. And they should be able to appeal saying that they were charged that amount in error. That's going to be a little bit tricky, just to be honest, sometimes. And that might be where you need to get some legal assistance, because getting that potential refund back from the insurer if they've paid part of their premium is likely going to be a little bit more of a challenge than just terminating the coverage. But I think this speaks to a couple issues, which is one, as soon as Medicaid eligibility comes through, consumers should actively go and cancel their marketplace coverage. Two, in many states, consumers may actually get retroactive Medicaid coverage because Medicaid can be available for the 3 months prior to the Medicaid application date. And that's when we get even more complicated circumstances. And in those situations, depending on the consumer's personal circumstances, they may have some situations where the marketplace covered services and they really would have preferred Medicaid to because of cost sharing or copays. That's when getting some additional advice and legal assistance is likely going to need to come into play.
Thank you. So with that, we will wrap up. As a reminder, we'll be distributing the materials from today's session via email, and we'll post everything to the Beyond the Basics website at www.healthreformbeyondthebasics.org. Our next webinar is scheduled for Thursday, March 5th at 2 p.m. Eastern, 11 a.m. Pacific. We will cover the recent changes to the public charge assessment, focused on how health coverage programs are factored into public charge assessments under the new policies. You can register for upcoming webinars on the Beyond the Basics website under upcoming webinars. You can also find additional resources on the website, including reference charts, guides, and frequently asked questions. If you have any questions or need assistance, please email our Beyond the Basics contact email at beyondthebasics@cbpp.org. And with that, we will bring today's webinar to a close. Thank you again for joining us today.